tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Well, it can be said that there's never a good lawyer around when you really need one. This is not true every Tuesday at 10 o'clock. David Whiting is a real good one. He is a Melbourne solicitor and he is here to take your calls. Hello, Mr. Whiting.
Oh, Mr. Smith, very nice to see you.
Very cordial greeting. Are you ready?
I am.
Oh, do you have any homework?
No
first
homework
no?
free.
Okay,
Yep.
Fine. We must fix that. Fiona is in Geelong. Hello, Fiona.
Hello, how are you?
Very well, thanks, Fiona. How can I help you?
Well, we were in a car accident recently where we went through an amber light and a car was turning and failed to give way to us and drove into the side of our car. We did a 360, landed in a pole. And the other party is refusing to use their insurance to fix our car.
Yes.
And my husband realised that he accidentally forgot to renew our insurance the month before, so we are uninsured.
Okay. Yes.
Yes.
Reminders
and
are
so
helpful, aren't they?
Yes.
Yep. What's
Yes.
the question, Fiona?
Can we pursue legal action for him to fix our car?
You can pursue legal action, but the first thing that's going to be assessed is whether there needs to be some kind of apportionment between the two of you, between the two drivers, as to who's responsible for what.
Yeah. Okay.
So what you might end up with is that you win as to 80%, the other driver wins as to 20%, which means that you'll pay 20% of their loss and they'll pay 80% of your loss.
Mm-hmm.
All right, so it's not going to be, yes, we'll fix your car, Fiona. It will be, let's see how we apportion loss because you went through on the amber.
Okay, right.
All right, so there's no reason at all why you can't pursue it. Was it an interview? Sorry, was it an intersection that had a traffic camera?
Unfortunately not.
No. Okay, well then it's going to be this discussion about who was watching and who wasn't, and why did the other guy start to go through. Anyway.
Yes.
So yes, it is an apportionment question, Fiona.
Fiona,
Okay, that's wonderful.
thanks for the call. Is everyone okay?
Yes, fortunately we had the whole family in the car, but we're all okay. Thank you.
Thanks for calling in. Jeff's in Hyatt. Hello, Jeff.
Hello, how are you going?
Wonderful. Go right ahead.
Look, we bought an apartment 5 years ago, and we were told there was 96 square metres internal and 21 outside. Some of the people are now selling, and when they're getting the agents out, they're being told that the apartments are something like 12 square metres smaller than what they were told originally. And this has happened to several of them. I just wonder if we got any comeback against the...
You need to look at the contract, Jeff, and it may well be that So if you look at the plan of subdivision that you would have been included in the contract when you bought off the plan, it will not have an area on it. It will tell you it'll show lines of the outline, but won't have dimensions. So, and you look at the contract, and the contract probably contains a condition that says that the apartment might be bigger or smaller by a percentage. And if it's within that percentage, you have no claim. If it's outside that percentage, you do, but there's a 6-year limitation period. Now, what was the state of the development at the time you signed the contract, Jeff?
It was finished. So there's 3 pods and 2 were finished, and we bought into the second one.
Which was finished. So your 6 years arose at the time you signed the contract.
Yeah, okay.
So the difficulty you've got is, yes, I told you it was 96 square metres or 91 square metres, but you saw it.
Yeah.
So the question is, did you buy on the basis of the measurement or did you buy what you inspected? If I was on the other side, Jeff, I'd argue you bought what you inspected. But get someone to look at the contract to find out if there is a misrepresentation and then work out, because if you were in the box, the question is you saw it, what was wrong with it? And the answer is there's nothing wrong with it. So the question is, what was the motivating factor for the purchase? The 96 square metres or what you saw? So which is logically different from someone who buys a property entirely off the plan and relies upon the measurements and then gets delivered with something else.
Okay.
Jeff,
you, Jeff.
Jeff, thanks very much for calling in. Michelle's in Berwick. Hello, Michelle.
Yes, good morning, David. I have a four-wheel drive diesel from a very highly regarded company, and the engine blew up. Pistons went through the cylinder head. Apparently, this is a fault with that particular engine, although mine's out of warranty because it's 2013. I believe there's a class action, 6,000 owners have taken against that company for that engine problem, but they're only covering from 2015 to 2020.
Then clearly the people running the class action don't believe that your engine is impacted in the same way as the other ones are. Otherwise, they would have made the class action for a longer period. So I would be trying to find out what specifically they're referring to in the class action. You should be able to do a search and get a copy of the pleadings, which will explain what the problem is with the engine, and you can use that to work out where you take your problem.
Michelle, thanks very much for calling in. Peter's in Kew. Hello, Peter.
Hi, David. Quick question. Car was stolen, smashed it, took it to a major repairer. They fixed it while it was in their possession. Someone else ran into it outside the yard or inside the yard. Now they want us to make a claim.
Another claim.
Again.
Well,
Well,
I'm going to ask you a little bit more than that, Peter. So they tell you the car's ready to pick up and it's parked out the front?
Correct.
So the question really is whether it's in their custody, whether it's in their power or control at the time the accident occurred. If it was, it should be covered by their insurance.
Correct, yeah. We hadn't came there and taken the keys off them yet.
No, I understand that. But it will be a question as whether responsibility has passed and at what point. So your argument is that it can't pass until you pick it up, inspect it and take the keys. So tell them to make a claim on their insurance, because while they were minding the car, they were responsible for it. But again, then look at any terms and conditions on their contract. But I think your better answer is that they still had the car.
Peter, Pete, thanks very much for calling in. Conrad is in Fitzroy. Hello, Conrad.
Good morning, Justin. Good morning, David. Thanks for taking your time. I've been renting a storage unit for 9 years, and so I'm a bit nervous, but...
That's all right, mate. Take your time.
He's worrying about Christmas presents.
They put my rent up without notifying me. They were supposed to give me 2 weeks' notice each time they do that. They've done that every time in the past. So I questioned it and kept on paying my original rate, and they kept on sending me the notice of arrears, which I was disputing, and then we got to the point where they sold my goods. They sold the whole storage unit.
Yes.
While we're still disputing the matter that they were saying I was in arrears, but I actually hadn't had any letter saying that my rent had gone up.
But you got new invoices with new rent.
Yes.
So the question, my view is that you're suffering the consequences of your own stubbornness. How many times did the rates go up in 9 years?
15, 12 or 15, yep.
Okay.
Every 6 months or so.
So let's take it this way. Let's assume that your rental starts in January. The following January, you get a new notice that says, it's gone up by $10 a month. Well, why would you not argue that that's only effective from February because they've given you notice? What you're saying is that because they didn't give one before the change, you don't have to pay any increases at all. And then they give you another one and you run the same argument.
But every other time they've given me a notice saying there's notice of rental increase. It's part of the standard contract that they have to give me a notice saying it's 2 weeks increase, not just an invoice. And then when they sent me through the notice that said they'd sent to me, it had the wrong address on it, and they'd sent it to a different address.
But Conrad, you got told every month what the rent was that they wanted. Why would that not constitute notice for the 11 months after the first notice was sent?
Because it's like when you have a tenancy agreement, it has to be a notice to vacate. It can't just be it has to have.
There are certainly
it has to have 2 weeks notice or the 3 weeks notice. That's required
there's
under
a
their
difference
contracts.
between a legislated change in the Residential Tenancies Act and a contract you've got with a bloke with a storage business about how and when and what the consequences are. So my frustration is that you've known for 9 years that these rates are going up. You just simply refuse to pay the increase. So I have lots of sympathy. I mean, I would have thought your protest would be, well, if that's the way you're going to behave, I'm taking my stuff away, as opposed to I'm going to make you keep taking money at the old rate.
Conrad, thanks for calling in. Gavin's in Gippsland. Hello, Gavin.
Hello, David. Listen, we bought a brand new motorhome 8 months ago, $180,000, and it's had issues from day one. It's been to numerous places to try to be fixed. As we speak, it's still in Melbourne, and we've not been able to use it at all for what we bought it for. And I'm wondering, we've asked it repeatedly if we can get our money back, and they just refuse to do that. I'm wondering...
Gavin, you have rights under the Australian Consumer Law which will cover the full cost of the motorhome. So have a look at the...
But can you tell me how you enforce that? Because there is no way that you can do that without going to court.
No, that's right. That's the court systems are there for the purpose of resolving disputes between people. There's no alternate strategy that works for Gavin of South Gippsland as a dispute resolution system other than the legal system.
This is ABC Radio Melbourne with Justin Smith.
And David Whiting is here, Melbourne solicitor, taking your calls. Karen is in Anglesea. Hello, Karen.
Hi, David and Justin. It's Karen, yes. Look, I have just one question. I have a little house in Anglesea, and at Christmas time and Easter time I do rent part of it out. I probably don't make more than about $4,000 per annum. And I've been now told that if I was to sell this house or die and on my death it's got to be sold, I have to pay a huge amount extra, or the executors or myself if I sell it, because it's a business. Now, I do have an ABN, but...
So is this the house you live in, Karen?
Yes, okay. It is.
And you move out and somebody moves in for a period?
No, I let them have part of it.
Okay. Then the answer is yes. Because the property is not for all of the period of ownership, your principal place of part of it's being used to generate income, and therefore you are going to be liable for an amount of capital gains tax, which will be depend upon the proportion of the house and the time for which you are using it to generate income. No. You're not using all of it full time. You're using most of it for most of the time. So there will be a portion that will be payable, but it takes account of the periods that it's available, which might be 8 weeks a year. And that's essentially the basis. So if you didn't start using it for that purpose until, 3 years ago, we'll ignore everything before that. But there will be... So it's kind of like... if I was to claim a tax deduction to use part of my house for an office, then that then becomes a calculation I need to take into account for capital gains tax. Right. All right. Now, even though 99% of the time it's being used other than as an office, and the other thing that you need to know is that there is a new state tax that starts, I think, in January, relating to income generated from this kind of rental.
Okay.
All right. So it may be less and less financially advantage.
It's going to be really mucky if I die for the people.
Well, it's going to be really mucky if you die anyway, Karen, let's be honest, right? So the question really is the quality of the records that you keep. And so they'll go to Airbnb and they'll say, well, for what periods did Karen have it available for rental?
Right.
Yep.
Okay.
Karen, thanks very much for calling in. Margaret's in Baldwin. Hello, Margaret.
Yes, good day. It's Margaret here. I just want to ask if I have any right to or appeal about the order made on the direction hearing. It said the applicant failed to appear at the direction hearing, but I was there. It said without without explanation. But I was there. I went to the Justice Center to check the list. It was not listed on the list. Then I went to the registry to say, oh, what's happening? It's not listed. And I was told, oh, it's been already heard in the chambers this earlier in the day. And
what was heard? So you have a listing for a particular date. Let's call it the 10th of December. You turned up on the 10th of December and you were told that an order was made on the 9th of December. Is that right?
No. It's been heard on the day, earlier in the day.
Right. So what time did you turn up?
Of course, I came. I was there before. It was supposed to be 2:15, but I was here around 1:45, looking at the display. There was nothing there, so I rushed to the registry and said, "Oh, it was not listed." And the man came out and said, "Oh, it was already heard early in the day in the chambers." Yeah.
Well, no. Then you're saying it was heard before your hearing time.
That's
then
right.
you're not wanting to appeal. What you want to do is talk to the registry about having the directions hearing relisted, or you might need
They've already made the order.
I understand that. So it might be that you do need to appeal. So it's an application for a rehearing.
Okay. So it's a separate application.
For a rehearing, you want it reheard, and it was because I wasn't there in the courtroom at the time the matter proceeded because it was listed for 2:15, but the orders were in fact made, and therefore it wasn't on the matters listed for the day. That's your process, Margaret.
Margaret, thank you very much for calling in. Sue is in Hurstbridge for you next, David. Go ahead, Sue.
Hello. I was robbed recently when I was on holidays, and I put in an insurance claim. The item of jewellery that was robbed had been given to me as a gift. There were two items, a necklace and a sovereign. The sovereign I'd had for 45 years and the necklace for 25. The insurance company wanted proof of purchase, which of course I didn't have anymore because it was so old. I did provide them with a statutory declaration. They gave me a paltry $750 on one item.
And that was the sovereign, was it?
No, well, it was just on nothing really. They just said, "We'll give it to you as a gesture of goodwill."
Sue, the sovereign would be worth $700 to $800, assuming it's a sovereign, not a half sovereign. And what do you think the other item's worth?
The sovereign's worth about $4,000, and the necklace is worth about the same.
Then what you need to be able to do is prove their worth, Sue. So it will be look through your family photographs. Are there photographs of the item of jewellery?
I sent them photographs of the item,
Well, then
wearing it on the day.
If you have a dispute with an insurer, you can take it to VCAT if you wish to, or you can take it to AFCA, afca.org.au, Australian Financial Complaints Authority. And the question will be, what were they worth? But can I say, I've just got an estate at the moment with sovereigns in it. To be worth $4,000, it has to be in exceptional condition.
Right.
All right. Okay. So that you need to prove their value. You need to prove they existed, and you need to prove their value.
Thanks for the call, Sue. Debbie is in Leopold. Hello, Debbie.
Yes, hello. I'm ringing on behalf of my son, Mac. He recently discovered he had a HECS debt when he did his tax return. Now, he didn't know he had this because he started a course in 2020 and then it got cancelled because of COVID. He did 12 classes. He deferred it and just didn't think he had a HECS debt. And now he's got a $9,000 HECS debt, and we've tried to have a HECS help debt rejection. We've gone through the process and they've rejected it twice. And I'm just wondering whether it's worth going to the Administrative Appeals Tribunal to take it further to try and get the HECS.
There is a I don't understand. If the course was cancelled, why did he defer?
Well, so they said they could do it by Zoom online, which didn't suit his...
So it didn't get cancelled. It got moved online because of COVID.
Yes.
And I assume that on what we call a census date, he was enrolled for the course.
Yes, correct.
So his liability is assessed at a census date, so X weeks into the course. So he did 12 weeks of how long was the course?
It was for, it was going to be for 2 years. So he didn't even get a trimester finished or a semester finished or anything. It was 12 classes and that was it, sort of thing.
And the course continued to be available but moved to online. I suppose your argument is not for it to be waived, for it to be reduced.
Yes. Well, yeah.
So I do think at the moment he has an obligation to pay, but Debbie, I'll have a look and I'll take that. Justin's desperate for me to have homework, so I'll take that as homework,
absolutely Debbie. Thrilled by that. Thank you very much, Debbie.
You're welcome. Thank you.
Wonderful work. Lynn's in Brunswick. Hello, Lynn.
Oh, morning, David. David, I live in a row of joined single terraces. I've had a fencing issue with the little portion at the back that's between the new neighbour and myself. A very leaning post. I got a fencer, took the phone number in. It was handed back. She's refusing to allow access to the property. It can't be fixed from my side. And I wondered, how enforceable is a fencing notice? I do have her name from the council. I know the name of the registered owner, and I don't know which way to take this.
Well, a fencing notice it's kind of like a letter of demand. It doesn't give you any rights other than the right to commence proceedings. But it says to your neighbour, this is the fence that's proposed. You can't do any work on an adjoining fence without the agreement of the owner or a court order. So the process is a fencing notice followed by a fencing summons followed by a hearing in a magistrate's court. And I'm just a little bit worried that you're going to be spending a lot of money on a very short piece of fence.
There's about a 30 centimetre lean, which means I have no privacy at that portion of the property.
Then the process, Lynn, is a fencing notice followed by a fencing summons followed by a magistrate's court hearing.
Lynn, thanks very much for the call. We've got time for just one more before we let you go, David. Kevin's in Heathmont. Hello, Kevin.
Oh, good morning, Justin and David. I was just ringing to just give you a bit of good news, positive feedback. David, you might remember Christmas before last.
No,
I rang about.
It was a good day, but I don't remember it particularly. No, Ken, let's see how we go. Kevin,
not that particular day, but just after.
Okay.
I rang you about an expensive bike racing wheel that was damaged on an airline flight. And the airline refused to compensate me for it. You suggested I go to VCAT, which I did. Took a year to get a date, and long story short, a month before the hearing, they wrote to me and said, we'll pay you 50%. And I said, no, but if you pay me 80%, I'll go away, which is what happened. But just for your information and for the listeners,
it works.
Definitely. It works, and definitely read the fine print, because their defence was we don't cover fragile items or sporting goods, and I read back to them their clause, and it actually says they don't cover fragile items, for example, sporting goods. And I argued that, of course, that wheel was in a bomb-proof box. I don't even know how they managed to damage it the way they did. It would have taken something extraordinary, really.
Thanks, Kevin. Can I say the bit that I get out of that is that it's the proximity of the hearing date that focuses the mind.
Yes.
So you issue a proceeding, and it takes a year before somebody turns their mind and says, oh, Kevin from Heathmont, we really need to do something about that.
Yeah, he is serious.
Okay.
Kevin,
Thank you, Kevin.
Thanks for the update and thanks for calling in. Isn't that just the length of time things can take to get done? I mean, it seems like it's not a small matter for Kevin, but just the length of time that things can actually take to get resolved.
I would have thought if you there are pluses and minuses. If the hearing's tomorrow, then the answer will be, well, I'll sue everybody. If the hearing's some 6 months out, I need to make a practical. So the question is, but 2 years is clearly too long.
David Whiting, Melbourne solicitor, you have homework, so we will let you run out the door. Thank you very much.